Next, Justice Sotomayor gets into the arguments of the state of Wisconsin. The state argues that when it comes to religious accommodations afforded by the government, courts should ask whether the accommodation's eligibility criteria are the product of invidious discrimination to determine if strict scrutiny applies. In support of that rule, the state draws on Gillette versus United States. Gillette, however, is an opposite. Wisconsin argued that when government makes an accommodation, the court should look at to see if the discrimination is invidious or obnoxious. In support of this argument, Wisconsin points to the case Gillette versus United States. Justice Sotomayor says this argument is inopposite or not pertinent. Unlike the conscientious objector in Gillette, which was equally available to members of all religions, the Wisconsin Supreme Court's interpretation of 108.02-15H2 facially differentiates among religions based on inherently theological choices. See, the remedies available to Gillette were available to members of all religions. But since that is the exact opposite of what the Wisconsin Supreme Court decided, they basically said that these entities of Catholic charities were not religious enough. The state next disputes the premise that petitioners were denied coverage because they do not proselytize or serve only Catholics in the course of performing charitable work. The state instead claims that petitioners were excluded because they engaged in no distinctively religious activity, meaning activities that express and inculcate religious doctrine. So the state claims that Catholic Charities doesn't engage in distinctively religious activity. I guess all those verses about feeding the poor and helping the needy aren't religious enough for the Wisconsin Supreme Court. Justice Sotomayor agreed. That understanding of the Wisconsin Supreme Court's ruling, even if assumed correct, cannot save the statute from strict scrutiny because decisions about whether to express or inculcate religious doctrine while performing charitable works are fundamentally theological choices driven by religious doctrine. Notice Justice Sotomayor's analysis. Even if the state's argument was correct, it would still be wrong, not because it was unconstitutional, but because it would trigger strict scrutiny. That is the court-created rule about how hard a government entity has to work to infringe on your rights. Section 108.02-15H2, as applied, cannot survive strict scrutiny because the state has not met its burden to show that the law's application is narrowly tailored to further a compelling government interest. So the court claims that the application of the law does not survive strict scrutiny because it is not narrowly tailored enough. All the justices agree, but two justices wrote concurring opinions.